picture the scenario. It is Friday night. It's been one of those weeks. You know, the kind where the emails just didn't stop. The deadlines were insane, and your boss was basically hovering over your shoulder until 4, 5, 9 p.m.
The absolute worst.
Right. So you finally clock out. You meet up with maybe 2, 3 friends at that new patio spot for happy hour. You have a couple of drinks, maybe a craft beer, maybe a margarita. And over, I don't know, 2 hours, you eat some chips, you laugh, you vent about the spreadsheets.
The standard Friday decompression. We've all been there.
Exactly. And you feel fine. You feel relaxed. Sure, the edge is off, but you feel totally in control. You walk to your car, you check your texts, you unlock the door. In your mind, you're a responsible citizen. You're not stumbling. You aren't slurring. You certainly don't feel drunk.
None at all.
You start the engine. But 10 minutes later, you see those red and blue flashing lights in your rearview mirror.
And that is the precise moment where the script of your life just flips. Yeah. Because what you feel inside your head and what the state of Texas says is happening are often two completely different realities.
That disconnect is terrifying. And that is exactly what we are unpacking today. We tend to overlook these, drunk driving or intoxication laws because we think we know them. We think, don't fall down, don't slur, drive straight.
Right. The simple rules.
But the line between legal conduct and a criminal offense in Texas is way more complex and, frankly, way scarier than just a number on a breathalyzer machine.
It is. Today, we're doing a full deep dive into Texas Penal Code, Chapter 49. This is the section of the law that governs intoxication and alcoholic beverage offenses. And we're not just talking about cars.
No, not at all. We were talking about roller coasters. We were talking about water skis. We were talking about how a single prescription pill from your doctor, taken exactly as prescribed, can land you in handcuffs and label you a criminal.
We're going to strip away the legalese. We're going to look at the chemistry, the biology, and the harsh reality of the penalties.
But before we dive into the statutes, a quick but really crucial bit of housekeeping. This show, these deep dives, they're a labor of love. We spend hours combing through the penal code so you don't have to. The only way we can keep the lights on and keep bringing you these insights is if you support the channel.
It really does make a huge difference. We want to keep doing this.
So right now, please hit that subscribe button. It helps us grow, it helps us do the research, and it ensures you don't miss the next one.
Also, check out our website. We've got resources there that break this down even further.
Seriously, hit subscribe. We'll wait. Okay, let's get into it.
Let's map this out. We have a lot of ground to cover. We need to start with the definition of intoxicated, because in Texas, it has two distinct faces.
Then we're going to look at the rules of the road and the water and the sky.
We'll climb the punishment ladder, how a mistake becomes a misdemeanor, and how that misdemeanor can spiral into a felony in, the blink of an eye. And finally, we'll hit the no excuses clauses. The things people say in court thinking it will save them, when actually the law has already slammed that door shut.
So let's jump in. Segment 1, the foundation. Section 49.01. How does Texas actually define being intoxicated? Because most people, they think it's just math.
Right. Most people think .08, that's the magic number. If I'm under .08, I'm free. If I'm over, I'm toast. But Section 49.01 is actually, it's like a two-prong trap. Yeah. Let's call them prong A and prong B. And here is the kicker. The state only needs to catch you on one of them.
Okay, let's start with the one everyone knows. Prong B, the science.
Prong D is the objective standard. It's what's called the per se violation. If you have an alcohol concentration of .08 or more, you are intoxicated by law. End of story. It doesn't matter if you have the tolerance of an elephant.
Right.
It doesn't matter if you can recite the alphabet backwards while juggling flaming batons. If the machine says .08, you are legally intoxicated.
And the source material gets pretty granular on how they measure that. It's not just blood.
Right. Correct. The statute defines alcohol concentration very, very precisely. It's the number of grams of alcohol per 210 liters of breath, 100 milliliters of blood, or 67 milliliters of urine.
67 milliliters of urine? That seems, oddly specific. Why 67?
It creates a standardized scientific baseline. The law is trying to create a conversion ratio so that breath, blood, and urine can all be legally equivalent. If you hit those numbers, the state doesn't need to prove you were driving badly.
Oh, I see.
They don't need a video of you swerving. The number is the proof. It simplifies the prosecution's job immensely.
Okay, so that's the math. That's the objective standard. But you mentioned prong A. And from what I gathered reading the code, prong A is the one that should keep people up at night.
Oh, absolutely. Prong A is the subjective standard. And this is where people get caught off guard constantly. The law defines intoxicated as Not having the normal use of mental or physical faculties.
Not having the normal use. That sounds incredibly vague. Who defines normal?
That is the million-dollar question. Functionally, it is a judgment call made by the arresting officer and later a jury. It means that by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, or, and this is massive, a combination of two or more of those substances, you are not functioning normally.
So let's play this out. I blow a .04. I am well under the legal limit of .08. But let's say I have a cold. I took some over-the-counter allergy medicine earlier.
So that makes you a little drowsy.
Exactly. And I have one glass of wine. The officer pulls me over for a broken taillight. I fumble for my wallet.
Yeah.
Maybe I stumble a little during the walk-and-turn test because I'm just tired. Can I still be arrested for DWI?
Absolutely. In fact, that is a textbook scenario for a prong A arrest. The officer determines that you do not have the normal use of your mental or physical faculties. He attributes it to the combination of the wine and the allergy pill. You are intoxicated under Texas law.
Wow.
The L.08 limit is not a safety net if your faculties are impaired. It's not a get-out-of-jail-free card.
That creates a massive gray area. I mean, normal for me might be clumsy. I might be a naturally anxious person who fumbles when a cop shines a flashlight in my face.
And that is the danger. The officer doesn't know your baseline normal. They only know what they see on the side of the road at 2 in the morning. If you look impaired and you have substances in your system, the law assumes intoxication. It splits faculties into 2 buckets, mental and physical.
Okay, break that down for us.
Well, mental faculties are things like your judgment, your processing speed, the ability to assess risk. Physical faculties are your speech, your balance, fine motor control like getting your driver's license out of your wallet.
I see.
And you can lose one without the other. You might be able to walk a straight line perfectly, which is physical, but you can't count backwards from 30, a mental task. That is still loss of faculties.
And looking at the list of substances again, it says any other substance into the body. That's a catch-all, isn't it?
It is so broad by design. If you sniff glue, if you take a research chemical that isn't even illegal yet, if you mix a sleeping pill with a Red Bull and it makes you jittery and unfocused, if it affects your faculties, it counts. It covers the entire periodic table if it makes you drive badly.
We're going to circle back to the prescription drug aspect later because that is a whole minefield of its own. I have a prescription defense.
Oh, it's a huge one.
But before we leave the definitions, we need to talk about what you can be intoxicated in.
Yeah.
Because when we say DWI, everyone pictures a Toyota Camry on I-35.
Right. The code defines motor vehicle, which is, the standard definition. But Section 49.01 also defines watercraft. This includes a vessel, one or more water skis, an aquaplane, or basically any device used for transporting a person on water.
Wait, water skis. You're telling me if I'm being towed behind a boat on skis and I've had a few beers, I'm committing a crime equivalent to drunk driving?
Yes. If you are being towed on water skis and you are intoxicated under that prong A or prong B definition, you fall under these statutes.
I just have this absurd image of someone getting pulled over on water skis. Like, sir, pull over to the wake. Put your hands on the handle.
It sounds funny, and legally it's rare to see a water skier prosecuted solely for skiing unless there's an accident, but the liability is there. The law is trying to cover every possible conveyance. But here is the one that really surprises people. Amusement ride.
Yes. Section 49.01, subsection 5. I had to read that twice.
The penal code explicitly includes amusement rides and mobile amusement rides. We are talking about roller coasters, Ferris wheels, carnival contraptions, you name it.
Now, to be clear, this isn't for the passengers. You can be drunk on a roller coaster.
Correct, thank goodness. This is for the operators. We'll get to the specific penalties later, but the law acknowledges that operating a tilt-a-whirl while drunk is legally comparable to operating a car while drunk. It is heavy machinery that puts lives at risk.
I guess it makes perfect sense when you think about it. You don't want the guy securing your safety harness to be seeing double. Okay, so we know what intoxicated means. Either the math, the .08, or the more subjective loss of faculties. And we know it applies to cars, boats, and roller coasters. Let's move to segment 2, walking and riding.
Right. Public intoxication and open containers, the offenses that can happen before you even turn the key.
Let's start with public intoxication, or PI. There's a really common misconception that just being drunk in public is illegal. Like if I walk out of a bar and I'm stumbling a bit on the sidewalk, I'm breaking the law. Is that true?
Not entirely. It's a nuance, but a really important one. Section 49.02 is very clear. A person commits an offense if they appear in a public place while intoxicated to the degree that the person may endanger the person or another.
So the keyword is danger. It's not drunk, it's dangerously drunk.
Exactly. Danger is the threshold. You can be happy, you can be loud, you can be staggering a bit, but until you present a danger to yourself, like, walking into traffic or looking like you're about to pass out in an alley, or a danger to others, like starting a fight or falling into someone, it's not technically a crime.
But there's a catch regarding where you are. And this feels like a bit of a legal trap.
It is. It's subsection A1. It clarifies that a premises licensed under the Alcoholic Beverage Code is a public place.
Which means a bar.
Exactly. A bar is a public place under the statute. So, theoretically and legally, you can be arrested for public intoxication inside the bar you are paying to drink in.
That feels incredibly counterintuitive. You go to a bar specifically to drink. You're paying for the alcohol. And the state says, you can do that, but if you do it too well, you're a criminal.
It's all about the duty of care. You cannot drink to the point of becoming a hazard, even in a place designed for drinking. Now, there is a defense here we should mention. Subsection B says it is a defense if the substance was administered for therapeutic purposes by a licensed physician.
So if you have a bad reaction to a medical treatment in public, say you take a new medication and you faint, you aren't a criminal.
Right. But generally, PI is a Class C misdemeanor. It's essentially a ticket similar to a speeding ticket in severity, though the immediate consequence is usually a night in the drunk tank until you sober up.
Okay, let's talk about the car again. Not driving yet, just having alcohol in the car. The open container law, that's section 49.031.
This is one of those laws everyone thinks they know, but the details matter a whole lot. The offense is knowingly possessing an open container in the passenger area of a motor vehicle on a public highway.
Let's break down open container. Does the cap have to be completely off? What if I took a sip of wine and put the cork back in?
It's broader than that. An open container is a bottle, can, or receptacle that is open, has been opened, has a broken seal, or, and this is the tricky one, the contents of which are partially removed.
So if I have a bottle of whiskey, I drank from it yesterday at a party, I put the cap back on, tight, super tight, and I put it in my cup holder to drive home. That's an open container.
Yes. The seal is broken, the contents are partially removed, it is legally open, it doesn't matter if it's not spilling or if the cap is on.
Okay, so where can I put it? If I'm bringing a half-finished bottle of wine home from a friend's dinner party, am I just breaking the law automatically?
No, you just have to stow it correctly. The statute defines the passenger area as where the driver and passengers sit. However, it explicitly excludes 3 places: a locked glove compartment, the trunk, or the area behind the last upright seat if the car doesn't have a trunk, like in an SUV.
So the glove box is safe, but only if it locks. An unlocked one doesn't count.
Correct. An unlocked glove box is considered accessible to the driver. If you can reach it while driving, it's a problem area.
And what about passengers? This is the classic Uber or Lyft question. I'm in the back of an Uber on the way to the club. Can I crack a beer?
Yes. There is a specific exception for passengers in a vehicle used primarily for the transportation of persons for compensation. That includes buses, taxicabs, and limousines.
And Uber and Lyft would fit that compensation description.
They do. There's also an exception for the living quarters of an RV. So if your family is driving a Winnebago down the highway, the people in the back playing cards can have a drink. The driver, obviously, cannot.
And just to be crystal clear, this applies even if the car is stopped.
Yes. Stopped or parked. If you're on a public highway, which includes the shoulder or the side of the road, and you are in the driver's seat with an open beer, even if the engine is off, you are violating section 49.031. You can't just pull over to the shoulder to sleep it off while drinking a beer.
Wow, okay. So that's the possession part. Now let's get to the main event, segment 3. Driving while intoxicated, section 49.04. This is the core offense.
This is the big one. Operating a motor vehicle in a public place while intoxicated. We've established what intoxicated means, 0.08 or loss of faculties. Now we need to look at the punishment ladder, because it is not a one-size-fits-all penalty.
It starts at a Class B misdemeanor. Can you translate that for a normal person? What does a Class B actually mean for my life?
A Class B misdemeanor carries a minimum term of confinement of 72 hours. That is 3 days in jail, mandatory if convicted. Plus fines up to, I believe, $2,000, license suspension, and insurance premiums that will absolutely skyrocket. It's a permanent criminal record.
But there are immediate ways to make that worse.
Yeah.
The law has these enhancements that kick in instantly.
Several. First, the open container enhancement we just hinted at. We talked about open containers as a separate ticket, a Class C. But if you are driving while intoxicated and you have an open container in your immediate possession, the minimum jail time doubles.
From 3 days to 6 days, just for having the can there.
Correct. It is still a Class B misdemeanor, but the floor is raised. The judge cannot give you less than 6 days.
Then there is the extreme intoxication rule. I feel like 0.15 is a number people need to memorize.
They absolutely should. This is section 49.04D. If an analysis of your blood, breath, or urine shows an alcohol concentration of 0.15 or more, the offense jumps from a Class B to a Class A misdemeanor.
That's nearly double the legal limit.
It is, and a Class A misdemeanor is significantly more serious. The potential fines increase up to $4,000, the potential maximum jail time increases to a full year, and the permanent mark on your record looks much, much worse to future employers. It signals, I wasn't just buzzed, I was wasted.
Now here is where it gets really dark and really serious. We move from general roads to specific zones, school crossing zones.
This is a specific provision, subsection E. If you are DWI in a school crossing zone during the time the reduced speed limit applies.
Like when the lights are flashing yellow, or when the crossing guard is out on the street.
Exactly. If you commit DWI there, it is a state jail felony.
We just went from misdemeanor to felony just because of where the car was geographically?
Yes. The law has zero tolerance for endangering children in that specific environment. It doesn't matter if you didn't hit anyone. Just being there intoxicated is a felony.
And speaking of children, we have to talk about section 49.045, DWI with a child passenger. This is the one that just destroys families.
This is separate from the school zone. This is about who is inside the car with you. If you are intoxicated and operating the vehicle and it is occupied by a passenger younger than 15 years of age, it is an automatic state jail felony.
Younger than 15. So your own kid, your niece, your little brother.
Yes. And I want to emphasize this. You could blow a .08 barely over the limit. You could have a spotless record. You could be driving perfectly straight. But if your 14-year-old is in the passenger seat, you are now a felon.
And a felony isn't just more jail, it changes everything.
No, it is a complete life-altering event. You're looking at state jail time, which is 180 days to 2 years, not county jail. You lose your right to vote. You lose your right to own a firearm. You will likely lose your professional license if you're a nurse, a teacher, a lawyer. It just destroys your life's infrastructure.
It really highlights how the law views the duty of care. When you have a kid in the car, the stakes aren't just higher, they were, exponential.
Precisely. You are the guardian. If the guardian is impaired, the state steps in with a hammer. It's viewed as a fundamental betrayal of responsibility.
Okay, we've covered cars pretty thoroughly. But as we teased in the intro, Texas Chapter 49 doesn't just stay on the road. Let's move to segment 4, planes, boats, and roller coasters.
This is where the code really shows its breadth. Let's start with section 49.05, flying while intoxicated.
FWI.
FWI, yes. Operating an aircraft while intoxicated is a Class B misdemeanor, minimum 72 hours confinement.
That honestly feels light. For flying a plane, I feel like if I fly a Cessna drunk, I should be in more trouble than if I drive a Camry drunk.
Well, you have to keep in mind, if you're flying a plane drunk, you are almost certainly violating massive federal FAA regulations, which carry their own very severe penalties. But under Texas state law, the base offense mirrors the DWI statute. It's treating the operation while impaired as the core crime, regardless of the vehicle.
Okay, that makes sense. The feds will get you anyway. What about boats? Boating while intoxicated or BWI? This is huge in Texas with all the lakes.
Section 49.06, operating a watercraft while intoxicated. Again, it starts as a Class B misdemeanor. But there is a very recent addition to the law, Section 49.061, which mirrors the car law we just discussed regarding kids.
The child passenger rule applies to boats now.
Yes. Boating while intoxicated with a child passenger, so anyone under 15, is now a state jail felony.
So if you're out on the lake, you're drinking beers on the pontoon, having a great Saturday, and you decide to drive the boat back to the marina with your kids on board.
Yeah.
Same deal. You are looking at a felony.
Exactly. The water is not a law-free zone. People treat lakes like private backyards, but the sheriff is patrolling, and the statutes are identical regarding children.
And finally, my personal favorite oddity of this chapter. Section 49.065, assembling or operating an amusement ride while intoxicated.
I love this section. It's just so specific.
I just love that assembling is included in the title.
It has to be. Think about a traveling carnival. They set up in a parking lot, they tear down 3 days later. The law says if you are intoxicated while operating the ride OR while assembling a mobile amusement ride, it is an offense.
That actually makes a ton of sense. If the guy putting the bolts in the roller coaster support struts is drunk, that's a ticking time bomb.
Exactly.
And does this have the open container rule too? Please tell me it does.
It does. Subsection C. If the carnival worker operating the ride has an open container of alcohol in their immediate possession, the minimum jail time jumps to 6 days.
It is both funny and terrifying to imagine a ride operator holding a beer while hitting the go button on the scrambler.
It is terrifying, and that is why the law exists. So far, we have talked about offenses where, theoretically, no one has actually gotten hurt yet. It's the risk of harm. But what happens when things go wrong? Segment 5. When it causes harm.
Now we are entering the territory of unexpected tragedy. This is where you can't walk away. Section 49.7 is intoxication assault.
What defines assault in this context? Because usually assault means I punched someone, I intended to hurt them.
In this chapter, intoxication assault acts differently. It means that by accident or mistake, while intoxicated, you caused serious bodily injury to another person.
By accident or mistake, that is so crucial. You didn't mean to hit them, you were just trying to drive home.
Right. If you meant to hit them, that's a different crime. That's aggravated assault with a deadly weapon. This covers the crash, the drift into the other lane. But the key term here is serious bodily injury.
And the source defines that pretty clearly.
It does. It means injury that creates a substantial risk of death, causes serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ.
So not just a bruise or whiplash. We are talking broken bones that require surgery, loss of an eye, losing a limb.
Correct. If you shatter someone's leg in a crash, that is intoxication assault. And the penalty is a third-degree felony. That's 2 to 10 years in prison.
And this applies to the boats and rides, too.
Yes. Cars, planes, boats, amusement rides. If you hurt someone seriously because you were drunk on any of those, it is intoxication assault.
And there's a specific enhancement here for brain injuries, right? This seemed particularly tragic.
Yes, Section 49.07c. If the injury is a traumatic brain injury that results in a persistent vegetative state, the offense is bumped up to a second-degree felony.
That is just heartbreaking. You'd leave someone in a coma, essentially.
And the law responds with up to 20 years in prison.
And then the absolute worst-case scenario, Section 49.08, intoxication manslaughter.
This is when the accident or mistake causes the death of another person. It is a second-degree felony.
So just to recap the latter here, you drive drunk and get caught, that's a Class B misdemeanor. You hit someone and they break their leg badly, that's a third-degree felony. You hit someone and they die, that's a second-degree felony.
Exactly. And again, I cannot stress this enough. The accident part does not save you. The intoxication is the legal cause of the accident. The fact that I didn't see him or he ran out in front of me becomes much harder to argue when you are intoxicated.
Now, we need to talk about the multiplier effect, segment 6, because if you've done this before or if you hurt the wrong person, the penalties just skyrocket.
Section 49.09 deals with enhanced offenses. This is the repeat offender statute.
Walk us through the strikes. How does it work?
Okay. If you have one prior conviction for DWI, BWI, FWI, or the amusement ride offense, a new offense becomes a Class A misdemeanor, and the minimum jail time is 30 days.
So the second time you get caught, you aren't doing a weekend, you are doing a month.
Minimum. And if you have 2 prior convictions, any new offense becomes a third-degree felony.
So the third DWI is a felony, period, even if you drive perfectly and just blow a .08.
Always. You are now a felon. And it's important to note that the priors can be mixed. You could have a DWI in a car from 1995, a BWI on a boat from 2005. If you get caught driving drunk today, that is your third strike. It's a felony.
That mixed aspect is interesting. The vehicle doesn't matter. The pattern of behavior matters to the state.
Correct. Now let's talk about who you hit. We mentioned first responders.
Right, this is crucial.
If you commit intoxication assault, so causing serious bodily injury against a firefighter or EMS personnel while they're on duty, it becomes a second-degree felony.
And if it's a police officer or a judge...
First-degree felony.
First degree. That is up there with murder. That's 5 to 99 years or life.
It is the highest level of felony in Texas. And if you cause the death, intoxication, manslaughter of a first responder or judge, it is strictly a first-degree felony. The state protects its own, very, very aggressively here.
There's also something called an interlock device mentioned in the enhancements. I've seen these on TV shows. You have to blow into a tube to start your car.
Yes. Subsection H mandates this for repeat offenders. If you are convicted of a second DWI within 5 years of the previous one, the court must order you to install a deep lung breath analysis mechanism on every car you own.
Every single car, even the one my wife drives.
Every car you own or operate. And here's the kicker. You have to pay for it.
The defendant pays. That can't be cheap.
It's expensive. You've got installation fees, monthly calibration fees. The court orders you to obtain the device at your own cost. And you cannot drive any vehicle without one. If you get pulled over in a rental car or a friend's car that doesn't have one, you go back to jail.
It creates a massive logistical and financial burden, essentially forcing sobriety if you want to be mobile.
That is the design. It is a leash.
All right, we are down to the final segment of the law itself, segment 7, the gotchas. These are the defenses people think they have, but the law explicitly shuts them down.
The biggest one, by far, is Section 49.N. It's just called no defense.
I love how blunt the title of that section is. It's not some defenses, it's no defense.
It is unambiguous. It says that the fact that the defendant is or has been entitled to use the alcohol, controlled substance, or drug is not a defense.
So translate that for us, because entitled to use sounds legal.
Okay. Imagine you go to your doctor, you have chronic back pain. The doctor prescribes you a strong muscle relaxer or a painkiller like Vicodin. You go to the pharmacy, you fill it legally, it has your name on the bottle, you are legally entitled to possess and take that pill.
Right. I'm following.
You take the pill exactly as the bottle says. You get in your car to go to the grocery store. You're swerving because the medication makes you dizzy and slows your reaction time.
And I get pulled over. I show the cop the bottle. Look, officer, it's prescribed to me. I'm allowed to take this. I'm not on heroin.
And the officer says, step out of the car. Being entitled to the drug, having a prescription, does not give you the right to drive while impaired by it.
I feel like so many people miss this. They think illegal drugs means cocaine or meth. But Xanax, Ambien, Vicodin, even legal weed from another state,
Right.
if they impair your normal faculties, it is a DWI.
Absolutely. Remember prong A of the definition, introduction of a drug or any other substance. A legal prescription is a substance. If you don't have normal use of your faculties, you are guilty. Period. The prescription is evidence of why you are intoxicated, not a defense against it.
That is a harsh reality check. And then there's the concept of mental state, section 49.011.
Strict liability. This section says proof of a culpable mental state is not required.
In most crimes, you have to prove intent, like, I intended to steal the TV, I intended to punch the guy.
Right. Or at least that you were reckless. But for Chapter 49 offenses, except for that open container ticket, the state does not need to prove you intended to get drunk. They don't need to prove you intended to drive badly. They don't need to prove you knew you were over the limit.
So saying I didn't think I was that drunk doesn't matter. Saying I didn't know the punch was that strong.
Irrelevant. The act itself, being intoxicated while operating, is the crime. Your mindset, your intent, your good faith belief that you are sober, none of it's a factor in guilt.
There is one small exception noted in section 49.12 regarding unborn children.
Yes. It briefly notes that the injury and death statutes, intox assault and manslaughter, do not apply if the conduct is committed by the mother of an unborn child against that child. So a pregnant woman who drinks and harms her fetus is not charged under this specific chapter.
Right. That's a very complex legal area involving other statutes, but it's good to know it's carved out of this specific DWI law.
Exactly.
Wow. Okay. We have unpacked a lot. Let's bring this home.
If we synthesize all this, what stands out is the sheer comprehensiveness of the Texas Penal Code here. I mean, it covers everything from the liquid in the bottle to the breath in your lungs. It covers vehicles ranging from a pair of water skis to a commercial airliner.
And the Ferris wheel. Never forget the Ferris wheel.
Never forget the Ferris wheel. But the takeaway is clear. The law is designed with an incredibly low tolerance for mixing loss of faculties with heavy machinery of any kind.
It really challenges that I'm fine mentality. Because the law has mechanisms, like this subjective definition, that completely bypass your opinion of your own sobriety.
That brings me to the thought I want to leave everyone with. We talked about prong A, the subjective definition, not having the normal use of mental or physical faculties.
Right, the judgment call.
Think about that. If you feel fine, but a police officer thinks you don't look normal, maybe your eyes are glassy, maybe you talk a little slow, maybe you just look tired, The law sides with the officer's assessment of your faculties, regardless of your BAC. You could be .005. You could be .000, but on a legal anxiety med.
It is scary because it begs the question, how does one truly know when they have lost normal use of their faculties?
Exactly. You usually don't know until it is too late, because the brain that is assessing your sobriety is the same brain that is impaired. You're using a broken instrument to measure itself.
That is a sobering thought to end on, pun intended.
Indeed.
Thank you for joining us on this deep dive into Texas Penal Code Chapter 49. It might save you a ticket, a felony, or something much, much worse.
Absolutely. Knowledge is safety.
Please remember to subscribe to the channel right now if you found this valuable. It really helps us out. And check out the website for the full breakdown. We will see you on the next deep dive. Stay safe out there.
Goodbye, everyone.